don't know your middle name. I don't know your birthday.
Suddenly, it felt like she was everywhere.
Samantha Markle, as you all may know by now, is suing her half-sister Meghan Markle for $75,000 in damages for numerous alleged defamatory statements attributed to Meghan directly and indirectly, with the latter, indirect statements, adding some considerable complexity to this case. The direct statements are the easier ones to tackle, and these are the ones arising out of the Oprah Winfrey interview made by Meghan herself.
I grew up as an only child. The last time I saw her must have been at least 18, 19 years ago. She changed her last name back to Markle only when I started dating Harry. So I think that says enough.
The indirect statements arise out of Finding Freedom, specifically Chapter 12, A Problem Like Samantha. Now, the reason that these statements are indirect is obvious. Meghan didn't actually write them down in the book and publish them herself. The authors of that book, being Omid Scobie and Carolyn Durand, are the ones who did that. Now, this comes into play and is very important when we consider the elements of defamation, primarily the first element. Suffice it to say that this can be problematic for Samantha, assuming her argument that all of these statements in Finding Freedom can indeed be traced back to Meghan's email to Jason Knopf doesn't work. So, what does Samantha actually have to prove to win this case? Because the media right now is pretty much having you believe that she's got it in the bag. She's gonna get it done, the truth will come out, and Meghan and Harry are going to be destroyed and annihilated in public, much in the same way as Amber Heard. I'm hearing a lot of Amber Heard parallels. But is there merit to this rejoicing? Premature rejoicing, I should say. Now, for a disclaimer before I proceed any further. I am an Australian lawyer. My knowledge of Florida's defamation law will not be precise. Having said that, I have built this entire channel basically on defamation law, and I've successfully tackled a defamation threat against myself. So I do know what I'm talking about. Very briefly, don't worry, I'm not about to bore you to tears with a lesson on defamation law, but it is very important to understand that there are elements to each and every crime or civil offense that have to be satisfied in order to win a case. So, the elements of defamation, which are pretty much the same in every jurisdiction I've ever covered, but specifically in Florida, are as follows. Firstly, the defendant published a false statement. And this has to be a statement of fact, not of opinion, because opinions are not defamatory and in fact are a defense. The second element is the statement has to be about the plaintiff. The plaintiff has to be clearly identified, or in Johnny Depp's case, you don't have to name him, but the implication was so clear that the public couldn't possibly understand the statement to be about someone else. And Johnny was successful, as we all know. Thirdly, this publication must have been made to a third party. And finally, the falsity of this statement caused harm or injury, not necessarily in a physical sense, to the plaintiff. As we covered in a lot of detail in my older videos from last year, each and every one of these elements must be satisfied in connection to each and every statement that Samantha claims is defamatory. If one of these elements isn't satisfied, let's say the plaintiff wasn't clearly identified, then the claim fails. And then there's a standard of proof to contend with. In this instance, as defamation is a civil offense, the standard of proof in the US is preponderance of the evidence, or in Australia, we call it on the balance of probabilities, meaning that something is more likely to have actually happened than not. So if you want numbers, I know some people like numbers, it's a 49-51 kind of split. Now, the burden of proof falls on the plaintiff, which means that Samantha, in this instance, has to meet this standard in relation to every single element that we just discussed. So it's not on Meghan to disprove the allegations, it's on Samantha to prove them. Now, I believe that Samantha is being considered a public figure for the purposes of this case rather than a private individual. And this is relevant to an extra element that exists when it comes to public officials, very much like the Amber Heard Johnny Depp case. If you're a public figure, then the plaintiff must prove that the defendant acted with actual malice. So actual knowledge that what they're saying is false, or they just had a reckless disregard for the truth. They didn't even bother checking. Versus the negligent standard, which applies to private individuals. Let's say if Samantha was absolutely virtually unknown. In that case, it's a much easier standard to meet because she wouldn't have to prove that Meghan did this on purpose effectively. All she'd have to prove was that Meghan was negligent. She was careless. Now, with these elements out of the way, a number of issues arise, which I have mentioned last year, and quite frankly, my opinion hasn't really changed. Now again, I will remind you that doesn't mean I am correct, but we're going to discuss later on in the video why there is some evidence to suggest that the judge has concerns as well. So without any further ado, let's get straight to the issues. In the interest of keeping things nice and clear and organized, I like organization, I'm a military girl. We'll tackle the Oprah interview statements first because they're actually the easier ones and we can get them out of the way before we get into the more complex issues arising out of the Finding Freedom statements. In relation to the Oprah statements, one of the two most relied upon defenses in defamation law are substantial truth and honest opinion, both of which I have successfully relied upon myself, by the way. Now, when I went through the statements in detail last year, I did raise concerns, and this was months before Meghan's team even filed their motion to dismiss, so I wasn't, stealing from them, that her feeling as though she was an only child and that she barely knew Samantha and that they weren't close can be her subjective experience of things. It's her perspective. It's how she saw her life growing up. It's how she felt about her half-siblings, which can slot under the defense of honest opinion. I wasn't making a false statement, Your Honor. I simply stated what my opinion was of the nature of my relationship with my siblings. Now, the meeting a handful of times statement can be a statement of fact because Samantha can easily prove, for example, that she definitely met Meghan more than just a handful of times, which can be used against Meghan and attack her credibility, because it essentially proves that she's a liar. She knows very well that she saw me consistently throughout her childhood and even throughout her young adulthood. And yet she chose to make that false statement in an effort to make me look like a liar, look like someone who is just an opportunist, who is trying to benefit and profit out of my relationship with my sister, which is essentially what Meghan is implying, by the way, when she said that Samantha only changed her surname back to Markle when Meghan became a household name. Samantha has produced evidence, by the way, to dispute that, being her graduation certificate. You can make out that it says Samantha Markle. But don't forget, with every single statement that we pull up, you have to consider all four of the elements. So even if it's proven to be a lie, Samantha still has to demonstrate that it caused her injury or harm to either her income or her reputation. If Samantha is able to defeat these two defenses, which Meghan did state in her motion to dismiss that she will be relying upon them. If Samantha can successfully argue and demonstrate to the jury, if it gets to trial, that these statements did indeed lead to the tanking of her book sales and led to an adverse effect on her reputation within her community, which she is arguing has happened, then she does stand a good chance of succeeding, specifically in relation to the Oprah interview statements. They fall within the statute of limitations, meaning that the time period during which she could sue over these statements hadn't expired. So there don't seem to be as many hurdles with these statements as the ones that we are about to tackle next. To me, the biggest and most difficult hurdle that Samantha has to bypass in relation to all these statements from the book is the first element. The defendant published a false statement. Here, Meghan is the only defendant. Again, this is something I expressed concerns over last year, where I stated, maybe Samantha should consider joining the authors of Finding Freedom and maybe even the publisher as co-defendants to increase the likelihood of her success. But of course, I'm sure her lawyers have their own reasons for not doing so. I mean, even Johnny Depp didn't sue the Washington Post. He only sued Amber Heard. That being said, Amber was the named author of that op-ed. This is not the case in this instance. As much as we all like to joke that Meghan basically is the ghostwriter of that book, I haven't read it, full disclosure, but from what I heard, there are a lot of personal details there that no one else would know other than Meghan and Harry. So while outside of a courtroom where the rules of evidence don't apply, we can all believe that Meghan essentially wrote that book, that won't fly in a court of law without cold, hard evidence proving that. So if the authors and or the publisher were joined as co-defendants, then this element wouldn't be so much of a problem. But Samantha and her lawyers do present an argument to, go around this issue. But again, it's such a complex issue that it may not succeed. So they're arguing that all of these statements in Finding Freedom can be traced back to Meghan's email to Jason Kanoff, where she listed all the talking points that she wanted passed on to the biographers so that they can include them in the book. This is where the issue of the statute of limitations comes in, which in Florida's case is 2 years from the date of publication. Now, this can make things very tricky for Samantha because Florida follows the single publication rule rather than the discovery rule, meaning that the statute of limitations, the time period, kicks in on the date that the defamatory statement was first published, rather than the date that the plaintiff discovered the defamatory material. There is an exception which doesn't apply in this case, and that is when the defendant republishes the material, having significantly altered it in some way. Now, Meghan's email was written in December of 2018, I believe, and Samantha brought this action in 2022, meaning that 4 years had elapsed since the publication of that email. And therefore, Samantha has missed out on that window of opportunity to take legal action over the contents of that email. But what Samantha is arguing is that this email was effectively republished when it surfaced online, in the public realm in November of 2021 as part of Jason Kanoff's evidence against Meghan in the privacy and copyright appeal between her and associated newspapers. However, there is a glaring problem with this argument, which Meghan's team does point out, by the way, in their motion to dismiss. Meghan didn't republish that email in 2021. As I just said, it was attached as evidence, as supporting evidence against her in relation to judicial proceedings, being the appeal. Now, this is problematic for Samantha because this would render this email as protected under the defense of absolute privilege, which is a defense in defamation law that is attached to any evidence that is published or shared in connection to judicial proceedings or even parliamentary proceedings, meaning that everything stated in evidence or witness testimony cannot be used against that witness in a defamation claim, as long as it was stated in connection to a judicial proceeding. So for example, oral testimony in a courtroom, or as in this case, written evidence or even affidavits or witness statements. So I hope you're getting the picture now when I say that these statements in particular out of Finding Freedom have a lot of hurdles for Samantha to successfully jump over if she has any hope of being successful. However, there's always a however, isn't there? There is still a chance that despite the latest update in relation to this case, which we will be discussing next, it could still never see a courtroom. Exactly a week ago, on the 7th of February, yes, it is Valentine's Day today, and I guess happy Valentine's Day to everyone who observes it and celebrates it. The judge presiding over this case, Judge Honeywell, denied Meghan's motion to stay, or delay in layman's terms, the discovery process, being the process in which both parties exchange all relevant evidence pertaining to the case. The media is once again going through this high, I suppose, of celebrating the fact that this means that Meghan and Harry, yes, Harry too, he has been served. No! My camera fell, so if the angle's a little bit different, I apologize. As I was saying, so if this case isn't dismissed by July of this year, if the reports are accurate, that is when these depositions are slated to take place. But as much as the media is rejoicing over this news, this doesn't automatically mean that the case will proceed to trial. And hey, don't shoot the messenger, because the judge herself has stated in this very order that after a preliminary peek at Meghan's motion to dismiss, some of Samantha's claims against Meghan are ripe for dismissal. And it's funny because a year ago, when I covered this case, I said the exact same things after going through the weaknesses in Samantha's case. I expressed my concerns. I said, oh, I don't know if this is gonna make it. And people who didn't like hearing that reverted to the oldest, I suppose, retort in the book, which is,
you don't know what you're talking about. You're not even a real lawyer.
In that case, I suppose Judge Honeywell isn't a real judge, because this is what she's saying, the very judge herself. There is concern. There are grounds for dismissal. I'm sorry if you don't like to hear it, but in a courtroom and in the law, things are handled a lot more rigidly than in the court of public opinion. But we can remain optimistic, because she says some of the claims are ripe for dismissal, not all of them. So it may be that the Finding Freedom claims are thrown out, but the Oprah claims survive. A mediator has already been appointed, because they have to go through mandatory mediation before this proceeds, if it is to proceed. And I believe it will be taking place later in the year. And if that doesn't succeed, if they fail to arrive at an agreement, that is when the case will proceed to trial, which, based on the reports I've been reading recently, will be in January of 2024. As for these depositions, Samantha is demanding that Meghan answers a long list of interrogatories or questions, some of which force her to admit certain things that may not necessarily be directly relevant to the case at hand. For example, admitting that the Queen, may she rest in peace, and King Charles are not racists. And she's also asking for documents proving that Meghan's Ford Explorer from her auditioning days that she loves to talk about, rags to riches, was indeed as broken up as she claims it to have been. Now, this isn't relevant to the case at hand, but I suppose what they're doing is trying to prove to the jury eventually that Meghan is a liar. So they're trying to attack her credibility as a whole, because in that instance, the defense of substantial truth, short of independent evidence, completely independent of Meghan's testimony itself, will be very easy to defeat. Because once a witness's credibility is shot, we all saw how Amber Heard was absolutely annihilated because Amber was deemed to be a liar by the jury. So everything they say is hard to believe. But Meghan's team is arguing that these questions are absolutely irrelevant to the case, and therefore we won't be answering them. Now, I don't know if the judge is going to agree or is going to compel Meghan to answer these specific questions, because, like I said, Samantha's team might argue, well, they're relevant to her credibility, Your Honor. But there are questions that Meghan has really no excuse, in my opinion, to justify failure to answer. An example of these is an interrogatory forcing Meghan to admit that she isn't an only child, and she does indeed have 2 half-siblings, being Samantha Markle herself and Thomas Jr. But Meghan refused to answer that as well. There is an alternative to this headache, and it would be the easy way out for both parties. Now, that doesn't mean it's the right way out, but it is nonetheless a valid option that still exists. Samantha is asking for $75,000 in damages. Now, this wouldn't be a made-up figure, it would be based on her losses, and I'm hoping that she has the evidence to demonstrate these losses. For example, her book sales, clearly, in a graph, taking a nosedive after the Oprah interview. But the point of what I'm saying is $75,000 are like pennies to the likes of Meghan Markle. So she could just settle this out of court and make it go away, which she may very well do, by the way, even at the very last minute, right before this case proceeds to trial, if it ever does. Now, this wouldn't only suit Meghan, by the way, because from a financial point of view, if Samantha were to lose, which is a possibility, then she would have to pay all of Meghan's legal costs. And being that it's Meghan Markle, they're going to be hefty. Probably something Samantha could never afford, unless she has some kind of a GoFundMe going for her. And while the rest of the world, the court of public opinion, will see this settlement as an admission of liability on Meghan's part, strictly from a legal perspective, that would be wrong. Settlements are not, in fact, an admission of guilt or liability, and in many settlements you'll find a very clear clause stating that this is not in any way to be seen as an admission of liability on the defendant's part. So Meghan would get out of it $75,000 short, and Samantha would get the money that she wants, because after all, that's what the purpose of a civil lawsuit is. Of course, for a plaintiff, it can be personal and you want to be vindicated in the eyes of the world. But the compensation, the only compensation that a court can offer a victim in a civil proceeding is monetary compensation. And that's what Samantha would effectively be getting if she settled. If I were Samantha's lawyer, I would personally make sure that I added a clause in that settlement, clearly stating that if Meghan were to ever repeat these statements in the public, that would be grounds for suing her in the future over these statements, even though they've already been tackled by the settlement. And I do this because knowing Meghan, much like Amber Heard, she's just incapable of behaving.
I don't remember seeing her when I was a kid at my dad's house, if and when they would come around.
Now, Samantha wouldn't be bound to accept this offer to settle if it's ever made, by the way, especially if it's unreasonable. But if it was reasonable, a cost order may be made against her if she loses, or if she wins but the jury determined that she is owed far less than $75,000, or whatever amount Meghan ended up offering in the settlement. So rejection should only be done after careful consideration of the offer. But I'm sure her lawyers know what they're doing, and they will be exercising the utmost caution when deciding whether to proceed if this ever happens. But yeah, to be continued, I suppose. Funny how this channel always ends up back in defamation law. I mean, it's like we're meant to be. I'm just gonna probably go now and wish you all the best. Happy Valentine's Day, bye.